Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. This morning I'm looking at a book which is in a series of publications from INTERSENTIA, based in Cambridge and in Belgium. This one is again about family law and will be of interest to anyone who's a family law practitioner, certainly to sociologists and advisors, and hopefully to people in CAFCAS and so forth. Now, the title of the book is The Child's Interests in Conflict. It's got a subtitle, The Intersections Between Society, Family, Faith and Culture. So you can see it's a very relevant book for the 21st century here in the United Kingdom. The book's been edited by Maarit Jantera-Jareborg. I hope I've pronounced your name correctly, Maarit. I'm sorry if I've got the pronunciation wrong. Now, my wife Elizabeth and I looked at this book and we've given the title for our book review the following: For all family law advisors concerned with modern thinking in children matters. Now, the book's available in terms of our review on the web and in the journals. And as I say, this is part of a series of books, which I'll talk about at the end. It's actually part of what is known as the European Family Law series. And I'll mention that at the end of the review. Let's just have a look at the book first of all. This is the book. It's a paperback. It's only a slim volume. There's the spine, and then there's the back. And I've taken some of the information from the back, which goes into our actual review. You'll notice here at the front there's the number 41. It's 41 in the series of books, and it's also come to us with a number of different organisations linked to it, which I'll mention in a moment. Let's go to the back of the book. The European Law series is slightly differently organised from our publications in UK, so you have the list of the actual series of books at the back of the publication. Then you've got a short index, which you can see there. It's not a big index at all. It seems to be on paragraph numbering, which would be the logic of it. Bearing in mind you can see here the actual paragraph numbering, but the paragraph numbering in the book is not quite as obvious as it is in some publications. There is right at the end an annex to the publication. If we go to the front, you can see here the actual front page, and there's some details about the other books in the series written by colleagues of Maarit's. And then you've got the details from INTERSENTIA, and then a useful preface which I've quoted from as well. The preface was written in 2015, so the book's a little bit older. Then there's the contents section there, and it lists all of the people who are involved as contributors, because Maarit has edited this, and there are a number of voluntary contributions, if I can put it that way, and the list of the authors are included there and there. Then you get to the book itself, and then for each chapter you have a very useful index for the actual chapter itself there. Then you get into the body copy itself with paragraph numbering, and there are copious footnotes throughout. You can see again we go into the book in more detail. State curriculum, parents' convictions under the European Convention on Human Rights, and so forth. All of which is very much up in the air. There we go through the book. All of which is very much up in the air at the moment because of the changes which we're confronting at the moment in the United Kingdom on leaving the European Union. So it's not the European Court of Human Rights issues that are going to be possibly affected in the shorter term, but obviously the Court of Justice of the European Union, as it's now called, the old ECJ, that's where the issues are. Please do remember the difference. I'm sure you do. The book runs to about 200 pages. So what do we say about it? Because I found this book very interesting. My practice is to do with welfare law, and I include family law in that, and certainly things like contact orders. But I thought this book was very important because the child's interests in conflict, remember section 1 of the Children Act 1989, as amended, is that the interests of the child are of paramount importance to the court. Always the general test in any court. So, child's interests in conflict has an important subheading which explains that the conflict is really the link or crossroad between society, family, faith and culture. Use the word intersections, but it's the same sort of thing. Now, the editor is Professor Maarit Jantera-Jareborg, and she considers one of the most pressing issues of any multicultural society the following: the conflicting demands on children from minority groups or children born to parents of different cultural or faith backgrounds. Now, again, I say that I'm interested in this from my own practice because that's really what I deal with. Now, in the preface, Maarit writes that the focus of the 9 contributions from the people for each of the chapters chosen is on one of the burning issues of any pluralistic, multicultural society encountering a diversity of norms, whether legal, cultural or faith-based. And we feel, therefore, it's a most important forward-thinking book for family practitioners to read now with the problems we face. And I say that not just from the point of view of the professional requirement, but I think anyone who's interested in this subject will find that this will give you a slightly wider perspective, may assist you when you're looking at some of the Kafkas reports and some of the contributions, the sociological elements of the contributions put therein. And I say that because quite often it doesn't quite make as much sense as perhaps it should do to either myself as a practitioner, certainly to the client and possibly to the judge. That is a matter, of course, for another day. Let me go back to the book. Some important issues are considered in the book, such as what a family may consider to be in the child's best interest and welfare in court when such decisions may not be shared by society at large. In other words, in the confines of the courtroom, we may be looking at things in a different way from what society in general considers. And these decisions, of course, are going to be and can be guided by faith, culture and tradition. Obviously, in our case, it's law as well, and practice. And our society may, of course, view the child as being exposed to a significant harm or to risk of harm if certain traditions are followed. And we all know what they are, of course, without going into any great detail. One major issue to be confronted is where parents might believe that their child is harmed or is in harm's way if such a tradition is not respected. Now, that could be seen as a twisting of particular things to suit a particular purpose by the parents, but also there are specific cultural issues which are put forward, which clearly are matters which the court must take into account. They certainly have in cases I've dealt with. I'm thinking of cases involving children who come from the African continent and particular countries there where culture, of course, is a very important matter. So what the editor and the contributors produce here is a focus on such circumstances throughout Europe. I know I've mentioned Africa, but the spillage from there is obviously within the European countries themselves, northern European countries and of course southern ones as well, of course. Now, the 11 contributors are all international leading experts in possession of interdisciplinary elements to review situations of conflict in the areas we're talking about, and that is a child's upbringing and education in general, the shaping of a child's cultural or faith-based identity, underage marriages, the circumcision of boys, the role of faith and culture in society's placements of children outside the care of their family, the role of faith in cross-border abduction, and disputes over parental responsibility. Now, much of that is what you will have as a practicing family law advisor, either barrister, solicitor, or any of the other groups of people who make up the mix of the family practice. Now, as to be expected, of course, the European Court of Human Rights decisions are raised here, and they're considered with some less well-known national case law as well to help. And obviously there are recent national pieces of legislation in addition, all of which show not only the complexity of the issues discussed, but differing ways in which multicultural challenges are dealt with. And the book considers how legal systems should navigate between the competing claims and conflicting interests without forgetting the main person to be protected, namely the child, and how the scope of tolerance, recognition and autonomy should be defined. And the title, as I've indicated, is part of a series of books which are dedicated to the harmonisation and unification of family and succession law in Europe, at such an important time, of course, for all member states of the EU as the UK prepares to leave it. And we're given useful insights into comparative legal studies and materials. And that's, of course, the beauty of a lot of the INTERSENTIA publications, which I think are actually not as well known as they might be, which is one of the reasons why I like doing these reviews. Can I say finally then that there is useful advice on studies conducted on the effects of international and European lawmaking within the differing European national legal systems. And what is most helpful for us here in Britain is the availability of these titles in English, French and German under the direction of the Organising Committee of the Commission on European Family Law, that's the CEFL, when there's considerable change in the offing for all of us. And the publication date for this book is 2017, and it's part of the European Family Law series. It's volume 41, which is mentioned there, and that covers European law, human rights law, family law, children's law and socio-legal studies. And I think it's a very well worthwhile book, this particular one. There it is again. You can see all of the links. The CEFL is mentioned there with the logos at the bottom. But that's the book. There's the back of it. You can see quite clearly what's on the back of it there. And if we open the book up, you can see, here we go, no possibilities of exception to marriage age. Of course, we've been getting this on and off over the decades, and it starts with the question, then it looks at the arguments and so forth. Again, an interesting point, then, is the argument for change, for instance, mentioned. We've got other areas. The body as identity marker, for instance. Again, the issues are very interesting, and if you look at the content section, you can see, subject to what's interesting to you, a whole range of areas which may be directly relevant perhaps to a case that you've got. Well, I'd like to thank Maarit and everybody at INTERSENTIA, Tom Shears in particular, and all the other people, very much indeed for producing these books. They're very helpful for us, and do have a good read of it because I found it very interesting and very illuminating. Thank you to all anyway. Bye-bye.